Welcome viewers to today's broadcast. My name remains Paul. Today's date is July 28, 2024. And as usual, I'm titling my broadcast Migrating to the US Useful Tips, Part 6. And today I want to very briefly discuss the visa categorization known as K1 visas. K1 visas is a non-immigrant visa category. It is in other words, you can call it fiancé visas. It's quite popular, it's quite unique, and it is also very encouraging. And so I would wish to state that I'm not very sure I'm going to finish the K1 visas at a go because it's going to be too long. And so I have decided to do them in different parts. Maybe could have part A, part B, or part C, but I'm starting with the part A right now. And so the K1 visa, or in other words called fiancé visa, is actually a process whereby a US citizen, the US citizen can be a lady, it can be a man, who wants to bring his or her foreign fiancé to the United States in order to get married. So the K1 visa is actually for a US citizen to bring his or her foreign partner to the US with the sole aim or purpose of getting married. All right? Now, so for that to happen, the US citizen has to file what is called Form I-129F. So this is the very first step. The US citizen has to file that petition to the Department of State seeking permission to bring the foreign partner to the United States. This is the first step to obtaining a K1 non-immigrant visa for your fiancé who is living abroad. And so you may have met this fiancé either online or in person, or maybe when you made a trip outside of the US and then the relationship blossomed and up to the point where you are now making plans to now bring in your fiancé, or you want to get married to your fiancé. And so you have to file that form I-129F. And like I said initially, the K1 visa, non-immigrant visa, is also known as the fiancé visa. So in order to obtain a K1 fiancé visa, the American citizen and his or her foreign fiancé must intend to marry each other within 90 days of your fiancé coming into the United States on a K1 visa. So your marriage must be valid, meaning both you and your fiancé have a bona fide intent to establish a life together. And the marriage is not for the sole purpose of obtaining an immigration benefit. In other words, it is not a contract arrangement. It is for real. The both of you want to settle together. You want to get married. You want to live together. You want to, stay as husband and wife. So, for your fiancés, if your fiancé marries you within 90 days of being admitted to the United States as a K1 non-immigrant visa holder, he or she may apply for lawful permanent resident status in the United States, or after you have done the marriage and everything has gone through, so your foreign partner who has now got to marry to you can now proceed to now file for adjustment of status, or can now file for a permanent residency, or what is called green card. So after that marriage ceremony and everything goes well, then your foreign partner can now proceed to now file for green card. Okay? Now, but for the American citizen, you must have to meet certain requirements. If your Form I-129 to succeed, you must meet certain eligibility requirements for you to even proceed to filing Form I-129 for your foreign partner. So for the American citizen, now for you to be eligible to file for a K1 visa for your foreign partner or for your foreign spouse, now you must have to be eligible, and your eligibility requirements are as follows. You may be eligible to bring your fiancé to the United States on a fiancé visa if you meet the following requirements. 1, you must be a U.S. citizen. Now, for you to bring in your foreign partner or spouse, you must be a U.S. citizen. Now, you and your fiancé intend to marry one another within 90 days of your fiancé's admission to the United States on a K1 non-immigrant visa. In other words, the American citizen and the foreign spouse or partner must have the intent to marry themselves within 90 days of the foreign partner coming into the U.S. or being admitted into the United States on K1 non-immigrant visas. So that marriage ceremony must happen within 90 days of the foreign partner coming into the United States. So again, you and your fiancé are both legally free to marry. This means you both are legally able to marry in the United States, and any previous marriages have been legally terminated by divorce, death, or annulment. So in other words, for the American citizen to proceed or to prove that he or she or both herself or himself and the foreign partner are having a genuine relationship, now the American citizen must prove that any previous marriages have been dissolved, annulled, or maybe the previous partner is now late or is no more or has gone, to be with the Lord. It's no more. So you must have to prove that any previous marriages must have been dissolved completely. In other words, you must have obtained your decree absolute, and then or the marriage has been annulled, completely cancelled, or the former partner is no more, or would have gone beyond. That's what it is. And so you must have to prove that. while you're filing the Form I-129. Now, furthermore, the American citizen must also prove that he or she met the foreign partner or the foreign spouse at least once within the last 2 years in person before filing the petition. In other words, that the American citizen must prove that he or she had met physically in the past 2 years with the foreign partner physically in person, either overseas or somewhere, but before the filing of the petition. And so you must be able to prove that you had physical contact at least once within the last 2 years before you can proceed to filing your fiancé visa. And so it is important and imperative that the American citizen must have met with the foreign partner in person outside of the US or somewhere else, but not within the US, before the filing of the K1 visa petition. Now, that said, now you may request a waiver of this in-person meeting requirement if you can show that the meeting in person would, one, violate strict and long-established customs of your fiancé's foreign culture or social practice. In other words, for the petition to succeed, the American citizen would have met the foreign partner once in person in the last 2 years. Now, but this requirement can be waived. And for it to be waived, there has to be proof showing that that physical meeting would violate a social practice, a cultural practice by the foreign partner. In other words, the foreign partner is forbidden within their own culture or social setting from having that kind of physical contact for whatever reason. It could be religious, cultural, or for whatever reasons is not permissible for both to meet. And so both the American citizen and the foreign partner must show proof that that meeting in the last 2 years was not necessary due to or shouldn't happen because of the religious inclinations or social cultural issues with the foreign partner. And so if that is done and it can be proved, then the Department of State can waive. The Department of State, through the USCIS, United States Citizenship and Immigration Services, can waive that physical requirement, physical meeting requirement in the last 2 years. Okay? And again, secondly, that meeting will result in extreme hardship to the foreign partner or to the U.S. citizen. If they can prove that that meeting would be unnecessary due to the extreme hardship that could occur, either that they could lose their jobs, either that one of them maybe had a sickness and was recovering, and so it was impossible, or that there had been other issues. But whatever be the case, it has to be proven beyond any doubt. And if the Department of State accepts it through the US CIS, then so be it. So the 2-year physical meeting requirement can be waived. That's what the issue is. And so these are some of the requirements for eligibility for the US citizen to even think of filing the Form I-129 with the USCIS. Now, he or she must meet those requirements. Now, if the Form I-129 scales through, in other words, that petition is approved. Now, the process for bringing the foreign fiancé to the United States, like I said, involves the USCIS, the U.S. Department of State, and the U.S. Customs and Border Protection. At each stage in the process, background and security checks may be conducted on both the U.S. citizen and the foreign fiancé. These may include checks in various databases for national security, criminal history, and other information about the U.S. citizen and the foreign fiancé. These checks are conducted using fingerprints, names, or other biographic or biometric information. So, the DOS, Department of State, works hand in hand with the United States Citizenship and Immigration Services, and also the Customs and Border Protection Agency. So all three will work together, do the necessary checks, the databases, criminal records, and all the fingerprinting, just to make sure that the U.S. citizen has no criminal records, or the foreign partner also is not a criminal. So these checks are routine and they are necessary. Okay? So I wish to stop at this point because I will continue the B part in my next video. I know this is a very interesting aspect, and which is why I want to take it bit by bit, just like I did with the student visas. And so, as usual, I want to see your comments. I want you to share. I want you to like. I want you to also put a call through or send me a DM if need be. I am on Instagram, Facebook. I'm also on YouTube and TikTok. I am growing my page, and I know as you keep sharing it, as you put your comment, as you engage with my content, that would help me. So I will be looking out. I will be hoping to hear from you. Whatever your comments are, whatever you don't understand, let me know. Whatever help you need, let me know. I will get back to you in good time. Until I come your way again, I remain your very good friend, Paul. Thank you for watching. Please share. Please comment. Follow me on TikTok, on Facebook, on YouTube, and Instagram. Thank you for watching. Until I come your way again, bye for now.